I've been asked to speak to you on the problems of protecting biodiversity at the local level, at the municipal level, and it's not a topic we can really do justice in 10 minutes, so I'll run through it, perhaps whet your appetite, and then you can come and consult me when I can charge you on... We all know that Section 24 of the Constitution sets out the environmental rights. And the difficulty that applies in respect of that right at the local level is that the national legislation gives very little power of enforcement to municipalities. So in NEMA and in NEMBA, the enforcement processes are at the national and the provincial level. So all of those wonderful things in those pieces of legislation regarding biodiversity protection are really enforced at the national and the provincial level unless there's been a delegation. And Section 156 of the Constitution limits the powers of municipalities. Those are those schedules you'll recall in the Constitution, Schedules B, Parts B of Schedules 4 and 5 of the Constitution, which set out the powers of the national government, the powers of the provincial government, the powers of local government. And environment, as defined, natural forests as defined, nature conservation are excluded from the jurisdiction of the executive power of municipalities. You might argue that biodiversity is not mentioned in those schedules, so it could perhaps be included in them, but it's specifically mentioned in the other parts of the schedule, Part A of Schedule 4, and it's given to national and provincial governments. So from a legislative and constitutional perspective, local government has a problem in enacting its own legislation for the protection of biodiversity. So unless there's an assignment, the net effect of that is that municipalities are completely excluded from executive control over the environment and over biodiversity. Now that's a very unfortunate consequence in some respects, and I'll come back to it. Because, for example, you see the extensive powers given to the municipalities under NEMA, where they really run the show. And there's a great deal of good sense in that, because in the local sphere, of course, air pollution is a very local issue. And it's better that it should be handled at that level than handled at the national or even the provincial level. So the Constitution very clearly has these areas of jurisdiction, areas of executive control, and as I've said, municipalities are excluded. Now, into that scenario comes the historic separation of planning and the environment. So the great frustration for both developers and municipalities is that there's no integrated processes for planning applications and for environmental applications. So even in the old ordinance days and in the embryonic days of environmental impact assessment, you had planning applications that went to the planning authority, and then you had environmental impact assessments which went to the provincial authority, in some cases to the national authority. And so you had the situation both when municipalities considered applications or when the DFA came into operation, that you had those bodies saying, look, we're not really going to look at the environment. I mean, I've had some cases which were bewildering, because in some cases the municipality or the province, which were considering an application outside a town planning scheme area, would say, we're not interested in the environment. But the shopping centre or whatever was proposed was going to be in the flood plan, and you'd say to them, but of course you've got to consider the environment. And they'd say, no, that's for the provincial government when you do your EIA. So this historic separation between planning and the environment was nonsensical, but was forced by the way in which the legislation had been presented. You had these silos of planning on the one hand and the environment on the other. So for developers, there was a great frustration that you had to go through two processes, and for the municipalities, the great frustration was that they could control, to a large extent, the planning process and the outcomes in the planning arena, but they had no power to control what or the outcomes were in the environmental arena, particularly if they had very high environmental priorities. Some of them, I know, tried to pass bylaws under the old pre-constitutional dispensation, and that kind of worked. But their difficulty was that they were only interested in affected parties in the EIA process. So they could go and wave their flag and say, we don't like this, but the province could say, well, we're the top dog and we'll make the decision. That all was thrown into great relief in the DFA judgment in the Johannesburg Metro Council versus the Gauteng DFA judgment. Some of you will be aware of it, some of you won't. Where effectively what happened was, and it had been a festering sore for some time, the municipality said, who is this DFA tribunal that can ride in on its white horse into our area of jurisdiction, our municipal planning function, which is clearly demarcated to us in terms of the Constitution, and tell us what to do in our backyard. And it came to the head when a number of the large metros, spearheaded by Johannesburg, took the DFA tribunal on review, and the Constitutional Court effectively said, listen, the Constitution has very clearly demarcated what are the areas of jurisdiction, and to the extent that the DFA tribunal tries to change planning schemes and tries to direct municipalities as to how planning will take place in their area of jurisdiction within their municipal boundary, it is unconstitutional. The unintended consequence of that judgment is, of course, the corollary. If that applies in respect of municipalities and the national government, of course the same must apply in respect of biodiversity. The difficulty now is, having, in a sense, laid down the marker that national government can't come and interfere with planning, the corollary is, well, then municipalities can't interfere with biodiversity management, which is a national and provincial competence. So that is playing itself out at the moment. Durban municipality has very controversially, well, let me take a step backwards. Durban municipality has for some time, the eThekweni municipality has had a DEMOS scheme, a very good scheme, a very elaborate scheme, which is an overlay of their town planning scheme, which demarcates those areas of important biodiversity value for the purposes simply of the biodiversity value itself, but also for what it calls goods and services. And I think that Deborah Roberts, who I think did her thesis on it and who was the champion of it in the municipality, I think she got it through council on the basis of the goods and services value of these biodiversity areas, because the municipality was told how many billions of rand they'd have to spend if they didn't protect these areas from the point of view of pollution and cleanup and all the rest of it. But however it got into law, it got in and it's become increasingly stronger. Because of the difficulties I've just outlined, and that is the municipality's frustration that they can't govern biodiversity decisions within their municipal area, Durban, I think a year and a half or 2 years ago, took the decision to incorporate DEMOS into its town planning schemes. So what it effectively said was, we are going to bring biodiversity management into our planning process. Planning is our neck of the woods, and we're going to bring it in, and we're going to govern biodiversity in a sense through our planning mechanisms. They introduced what they called a DEMOS controlled area. So they moved from, in a sense, an overlay over their town planning scheme to integrating it into the scheme controls. They introduced a uniform clause 10. I don't have the time to go through it, but I would just highlight it. Effectively, you can't have any development without approval in respect of biodiversity impacts. The test for those impacts is the integrity of the biodiversity and the goods and services. Goods and services being in a sense, the goods and services supplied to the municipality from those areas. And it also requires that there should be an application made in appropriate cases when directed by the head of the relevant department, which is analogous to an EIA. Now, immediately I say that, for those of you involved in EIA, you say, well, what happens then if it's required to get an EIA for a particular development to go to the province under the EIA regulations, but in terms of this clause you have to go to the municipality and in a sense get an EIA as well? What if the city says, we don't like the outcome of the province's EIA, or the environmental authorization. We're going to make our own. You end up with a conflict where you get municipalities saying no and the province saying yes, or vice versa. So it's a problematic issue. So I suppose the question to pose, apart from whether lawyers have any social utility, is this incidental to planning? Or is this outside its constitutional competency? Section 2 of NEMA implores and requires all organs of state to apply the principles in NEMA. Wonderful statements of sustainability. But the difficulty with that section, it says that municipalities must utilize their existing powers, or organs of state use their existing powers. It isn't a section which confers or gives a right to municipalities to, in a sense, increase their powers or take on additional powers. So Section 2 of NEMA is not the Section 2 of NEMA is not the panacea for this. It doesn't give the inroad that they would require. Because the stated aim of DEMOS is to protect biodiversity, I think they've got a problem. If perhaps they said, no, it's only to protect the goods and the services of the municipality, the sense of its physical hardware, perhaps they would be able to get in through a different leg. But it is to protect biodiversity. The third difficulty is that what this clause 10 has sought to do is to give power to the municipality at any time to amend the boundary. Now, we found at times when we're representing clients, you can go onto the municipality website and you can see where the DEMOS boundary is. Sometimes it's changed because someone has decided, actually, because of some process, to increase it. If this is a zone, if it's going to become a planning zone, that ability to just unilaterally increase it or change it, of course, has huge implications for landowners. So the question of how this zone integrates itself into a kind of planning overlay or a planning zonation is a difficult issue. And I think that in itself creates a problematic aspect of the proposals. There's a huge discretion, as I've already pointed out, to direct that this thing goes to a separate EIA. And that, of course, creates an immediate conflict with the provincial legislation, national legislation. And then, of course, what happens if the municipality says you may not develop this at all? So you have a piece of land that's zoned special residential. You've bought it with that zonation, which was imposed by the municipality originally. You spent a great deal of money buying your dream property and are about to develop, lodge your building plans, and then you're told you can't develop. What about compensation? So I think that it may well have strayed outside its competency. I think that the environmental planning division is very hard to draw. I think there's a crying need for an integration of planning and EIA. Many years ago, I proposed we go the New Zealand route, where we have a Resource Conservation Act, which incorporates both planning and environment. But whichever way we go, there needs to be a workable, competent, independent arbiter if you end up having disputes. And I think that's the problem with these silos and with what the city is trying to do. I'm about 30 seconds over time. I hope that wasn't too fast. Thank you.
Thank you for the presentation. I'm sure all of us in this room will agree we will need enough time to ask as many questions as possible, because after this, when you ask a question, you're going to be billed. So this is your freebie time to ask questions. Can I invite 2 questions from the floor? I've seen 2 hands at the back first, and then Andy. Thank you.
Thanks, Norman. Building on, I think you did allude to it, but surely the municipality would be best placed to say that it's not actually pursuing DEMOS from a biodiversity point of view. It has an exclusive competence in disaster risk management. It's got some competence in water services, fire management, etc., etc. And there's a whole range of completely non-biodiversity arguments that the municipality could use to really reinforce and secure the ecological infrastructure that is the demos.
Yes.
And that would be the easiest way for them to get around any challenge. The question then becomes a matter of procedural integration of EIAs at one level versus planning.
Yes, I think it's not necessarily a nothing or an all. I think if it was constitutionally challenged, the Constitutional Court might say, listen, actually this aspect is problematic, that aspect is problematic, and they'd have to tailor it and perhaps take out those elements of biodiversity management.
Thank you. Andy?
Thanks, Chair. Norman, you've indicated that the silos is not a good thing, but there's also a flip side to that in terms of the Max Sands decision in Cape Town, where the municipality was able to use its planning silo to prevent mining, which had a biodiversity consequence, a positive consequence. And my question is, is that just not the arena that we're dealing with, that there are different ways of achieving different outcomes?
Yes. Look, I agree with you, and it's a whole debate in itself. I remember when we were looking at the original Planning and Development Act, there was an academic who came out from America, and he said, in America, everything's gone down to the local level. And he said, it's been a complete disaster. Because at the local level, you get all sorts of pushes and pulls, politics and all those sorts of things. And if you're going to make them complete arbiters to be able to decide their own affairs in every respect, you're going to end up with a big mess. You have to have some sort of overview. So his view was with the silos were quite a good idea. But I think there needs to be a measure of integration, and then there's got to be, as I said, some sort of independent arbiter so that you can take it out of the municipality. And that's the difficult at the moment. There's a great debate about what happens to appeals. Municipalities, particularly eThekweni, are saying, hold on, you can't bring in an appeal body here. We decide and we are the final decision maker. I think that's wrong. So I think that there needs to be some independent, removed, competent arbiter in these cases to say, hold on, what's going down here, guys? We need to have a good look at it.